3/6/2022, 24. 2 weeks time was granted for again listing, my lord, because I was on that day leave. The matter has not been listed. So, my lord, on Monday, this is a
This will
very
come for order or for admission?
It is my lord motion, my lord.
Motion.
Monday,
what?
my lord.
Revision petition or what?
Criminal petition, my lord.
Will not come for motion, it will come for admission.
No, criminal petition is the first day, my lord.
9th
9th,
Friday, next Friday.
not, is it not possible, my lord, before?
Then 12th.
My lord.
12th.
Then 9th, my lord.
Okay.
May I please, your lordship? I beg to mention for item number 11, taking adjournment that my senior is out of station. The matter may be come on 12.
Hold on, hold on. These are order matters.
Yes, lordship.
We'll pass the order, wait for that part.
May I please, your lordship? I beg to mention item number 15 of today's hearing list. With the consent of the other side, the matter may be adjourned.
Okay,
for the-
first let the matter reach. We'll see only one hearing item is there. Let the matter reach.
May I please, your lordship? My lord, I beg to mention item 3. My learned pen
Item
is
number?
3, my lord.
Ah,
My learned pen is appearing on behalf of respondent. My lord.
ah.
My lord, he is saying, my lord, I will file counter affidavit, my lord. My lord, it may be come after 2 weeks, my lord.
On the prayer of the council for the parties, matter be adjourned for 3 weeks. Registry shall place the matter for admission on the date to be fixed by the registry accordingly. In the meanwhile, the respondent numbers 1, 2, and 3 shall file their objection of affidavit in opposition, if any, in the matter
Obliged, my lord. My lord.
within this period of 3 weeks.
I have to mention for listing of criminal proceeding against the NBW in a NI act, NI proceeding, my lord. So that the date has been fixed on 8th, my lord. Next. On Monday, my lord, finally, my lord. My lord, because on 8th, the date is fixed, my lord.
7th,
7. Obliged, my lord. 7, my lord. 8 on.
doesn't matter, 7th. You have also chosen to select today only. Today is 2nd, you are aware that proceeding is pending. He did not appear.
But I have filed
Mentioned in the-
on.
That is why. Have it on 7th. Yes.
Lordship, I beg to mention on listing. Lordship, this is a proceeding under this criminal petition under 482, Lordship. The lower court proceeding is on fixed on 7, Lordship. Can we list on 6th, Lordship?
When the order was passed?
Or passed on Lordship 23,
23rd of,
in 2023, Lordship.
perhaps Susan now. You have the matter on 6th, you want the Port Sapunda court to have the matter on 5th. That cannot be, when you are fully aware of that thing.
Can it be taken on 6th, Lordship?
6th is Tuesday,
Tuesday, Lordship, yes.
it's a hearing day.
In it is for Lordship, it is for it is pending matter, Lordship.
Is it pending?
Yes, Lordship.
On 5th.
5th, Lordship.
Yes.
6th, Lordship.
5th, not on 6th. It's a hearing day. You make a mention in the morning in the 5th.
Lordship.
5 তারিখ date দিতে পারছো।
Lordship, my difficulty that in this case, Lordship, my senior advocate, Mr. R.P. Kakoti, will be conducting this matter. Lordship, 5th.
We'll go, we'll see.
Lordship,
Don't worry, if it is required, then we'll fix it on 6th. Let it come on 5th first. Yes,
May it please your lordship, my lord, prayer for listing of a matter
for what? Admission or
for motion,
what kind of petition?
criminal revision petition. My lord, is a pending matter. Last
Why
time
for
prayer-
motion? Notice was issued.
Yes, my lord. My lord, it's regarding non-payment. My lord, they haven't paid. They've only paid the first installment. My lord, as
What was the
per
last order?
22/5.
What was the order passed?
Order was
On
passed.
22nd of May, what order was passed?
My lord, the petitioner was to pay the money to the respondent. However, my lord, they have only paid the first installment. After that, they haven't. My lord, it's been over a month.
When
and
did
they
you
haven't-
appear in that matter? You are
My
for
lord,
the
I haven't
respondent.
appeared in that matter.
You have appeared for the respondent.
Yes, yes, my lord.
On 7th for admission.
Obliged, my lord.
May I please, your lordship. Lordship, I beg to mention for listing
my lord, criminal petition, my lord, orders, my lord. Earlier mention was allowed, my lord,
but
but
not
not
listed.
listed.
Okay, on 12th,
My lord,
12th for all this.
9th August,
You want on 9th? 9th.
my lord.
Lordship, I beg to seek adjournment for item number 5. Lordship, I am representing on behalf of Mr. Amit Goel, petitioner's counsel. Lordship, the counsel is out of station. Lordship may be pleased to provide a short date.
Wait for some time, wait for some.
Much obliged.
May I please, Lordship? Lordship, I want to withdraw this matter with a liberty to file a press. Why we want to withdraw this matter, Lordship? We have wrongly annexed one annexions, Lordship. That is why it is difficult for us to proceed with the case. As such, we want to withdraw this matter with a liberty to file a press.
Which annexer?
My lord, annexer 6, Lordship.
Will you kindly tell us the page number?
No, no, Lordship, annexer 7, Lordship, page number 46 to 79. Lordship, what happened in this case? There was an incident between the victim and the informed accused person. There was a cause affair from both the parties, Your Honor. Your Lordship.
Then,
Lordship, we have come up with this criminal petition for quashing of the charge sheet, which the police station filed against us. Lordship, we wrongly annex some documents. Lordship. That is why we want to withdraw this. Lordship, Lordship, kindly come to the synopsis, Lordship.
what's your good name?
Our hope, Lordship. Lordship,
Mr. R. Hawk, and counsel for the petitioner. Submits in that. There is some mistake. In annexer 7 of this criminal petition. That was inadvertently caused during filing of this petition to parties, which is I got to annexer 7. Is correct while filing this criminal petition. As such, on instruction of the petitioner, the Hawk plays for withdrawal of this petition with a liberty to file a press. Any objection? To which Miss and thus learned listen for the prosecutor.
may I please, my lord? My lord, I may be allowed to receive the original copy of the impugned order so that it will be fruitful for us to file the
That is up to you. Here annexer 7 is not a certified copy. You want what?
impugned order, Lordship, impugned order, Lordship.
Which is the impugned order? You have not annexed.
We have impugned charge sheet number 553 of the 2023. That is, Lordship.
To which no objection. Mr. Hawk, also prays for an order directing the registry to return him the certified copy of the order digit 1901-2024 passed by learned Subdivisional Judicial Magistrate within bracket Mofasal, Bilasipara in PRC number 03024 along with the certified copy of the final report filed by investigating officer of the case relating to Bilasipara Police Station case number 391/2022 dated you get the charge sheet finally charge sheet relating final charge sheet next dated 31/12/2023 link to charge sheet number code 553/2023 dated 31/12/2023 filed in connection with Bilasipara Police Station case number 391/2022. That has been annexed to this petition. তার পাথরে লিখবা 2 weeks. Prayer allowed. Liberty Supreme Court and aspect to them. Registry sir. Return such and such. Certificate authority. Obtaining to the learned counsel Mr. R. Hawk. What's your full name?
Rajul Haq.
Obtaining his acknowledgement with date.
And the blood loss.
Yes, Mr. Ali.
Hello, here we have changed the Hilton order is a page. Annex 6, page 44, that taking cognizance of the offence under section 302 and against the and proceedings, my lord. Because in this case, what happened, my lord, one FIR was lodged at page 14, my lord, by the opposite party number 1, my lord. And because alleging that his brother.
Miss Jahan, just a minute, please take your full certificate. Yesterday night while I was inquiring, probably there is a case with regard to 156(3). We may be wrong in passing orders. You see, after such order passed by the magistrate and an inquiry, if police find some heinous offence committed, do not report it, not complying with the 171, 172, whatever, filing the FIR or filing the application before the Superintendent of Police by registered post. And during investigation, if it is found that there is involvement of the concerned petitioner, the accused, the complaint petitioner, during investigation, a search sheet is filed. In that circumstances, 156(3) stand is different. Since tomorrow and day after you have some holidays, please look into it.
Then I'll have to look into it.
Yes,
Like,
because in that manner, it has to be, there may be some direction to convert it into 200. Got it? Because during investigation, it was found that the particular accused have committed the crime. and the search sheet has been filed.
But then those requirement of 154, 1 and 3 are not complied with.
Not complied with.
But then the court's order is to register the case and proceed.
In that circumstances, already up to the level of filing of search sheet and taking of it, cognizance also came to certain extent. In that circumstances, there is some judgment.
Ah,
Probably 156(3) that law laid down by Sakira Basu may not be,
not be applicable.
because Sakira Basu relates to only with the High Court coming for the petition in the Commonwealth 140.
Ah.
That's why, otherwise everybody will come. That's what is finding it.
Ah, ah.
So in that circumstances, kindly look into it. Probably in that circumstances, we have to consider it, because entire proceeding will not go. Once the FIR is passed,
Uh-huh.
that order of the land magistrate directing the police station to register case and this thing. Something is there. So
There is a difference. Simply registering the case after the complaint under 156(3) and courts issuing an
there is
order.
a difference. See, basically, during investigation, if the accused comes before the court saying that the entire proceeding is that because of this approach, that is one aspect of it.
Achha.
The second aspect of the matter, after, in the meanwhile, the investigation was complete in terms of the order of the magistrate.
Achha.
And the report under final form was also placed before the magistrate. Right? That means search sheet was fine. And if
And
the
in
search sheet
that
was,
case-
in that circumstances, cases will be different.
But the fact remains the initial.
Right, but that thing, that is only, that is technicality.
Ah,
It is the technicality is that some decisions are there.
then this is a very important thing we'll have to.
Find out, because I read only 2-3 lines. There it said, they did not, in that particular judgment, there was no such mention that it was decided in that case or so. That was, it was difficult for me to find out. But in that judgment, I did that in that circumstances, this,
Ah.
and the matter proceeded.
Matter proceeded, it resulted
That,
in
in
final
that
form.
particular judgment, what I found that issue relates to something else, but not with 156(3). But the Honorable Apex Court has considered this aspect.
Oh,
That in that application under 156 was filed, and then magistrate passed an order, then passed this, police registered the case, investigated the case, filed search sheet under these sections. Then it proceeded something else.
achha.
In that circumstances, because the Apex Court did not deal with that issue. And Sakira Basu's judgment was much prior to this order of the Honorable.
Sakira Vasu only, Sakiri Vasu
Sakiri Basu.
is only that it is registered on an 156(3) application without
Which
taking the
cannot
course to.
be. Subsequently,
But
Priyanka's
it's court's order and everything, charge sheet and all, that means the petitioner has approached the court late. In that circumstances, things will be
we
different.
don't know that, just kindly look into it,
Ah.
because the matter relates to facts of the each case, right?
Facts of the case, yes.
Whether in that circumstances, simply because it was filed under 156, probably we cannot.
Hmm.
Because we have passed 2 orders on last 2 occasions.
Uh-huh.
There was a case in similar circumstances when the charge sheet was also filed.
There were 2-3 cases, I think.
Right.
it's, lot-
Simply not up to the level of registering a case, we can understand.
Hmm.
But in one case, charge sheet was filed,
Investigation
was taken.
completed, charge sheet filed, it went to court.
cognizance taken. In that circumstance, because I'm
that-
thinking probably we may. That order I have not yet signed, so it's not yet from, that is the reason we're going to. Please do some homework.
Yes, sir.
We'll also try to do,
Monday I'll get back.
try to find out. There are some, because otherwise the Honorable Apex Court did not have continued. Once it comes to the notice of the Apex Court, they would have definitely,
There. It's-
otherwise they proceeded with that case and passed all. Okay.
Lakshmi, okay.
May I please?
Just a minute. Ms. Jahan,
I've gone through those 202 statements. They're taking him from his place as well as dying declarations are there in the evidence. So in that view of the matter,
not only that, what we found that while filing the final report, DIO did not submit the postmortem report of the deceased.
Postmortem, I don't find it
Only the
anywhere.
medical report is there.
Hmm.
And medical report says that he sustained blunt injuries.
Hmm.
All are anti-mortem.
Hmm.
Now, it's very surprising.
Hmm. The final report is very short.
And then how come the investigating officer
Hmm.
could have filed the final report
Hmm.
without the
PM report.
PM report?
2 times.
And not only that, in fact, after that obtaining that report, the body of the person disease was not forwarded for PM.
That is also nowhere it
How
is
come?
said.
No, it is not there because in the record what we found, there is nothing on the part of the concerned investigating officer.
Because had it been an accident case also,
Even
they
then,
have to be said.
had to be person had to be, investigation had to be there by making postmortem examination. In the
record.
in the investigation, there is no mention. There is only a medical report.
Hmm. Postmortem was otherwise done.
No, I don't think so because it is not there.
Even
The-
accident can also postmortem is.
Oh, is required.
But that is in record, I don't know, madam, but not. That big-
From the breach and.
That part is.
Because in that part, they have done PM. But thing is this, the PM only one page report.
But in the final report, it is mentioned that there is
There
a,
is mentioned, but there
there
is
is
the
a postmortem report is there, my lord.
IO did not place
It is
it.
actually mentioned.
It is not available.
Final report.
Only
Postmortem the কথা.
those portion, cause of death,
Put it. It should be in the record because we have got the copy, one copy of the postmortem report here. madam. Explanation maybe.
PM was done.
PM
It
is done.
seems, but
Even
no
the
date, nothing.
Obtain copy also. maybe.
What is it? PM or here?
Yeah, I mean, again, annex to one.
Oh, अच्छा.
But, yeah, it's on this. Chapter number. कहता है नहीं, it is on.
They mention it at page 26.
That we have seen.
3 numbers of, it is.
The record contains only one page.
Hmm. This is, they have handed me over the PM report. There it is said injuries are grave abrasion over the forehead, laceration, face.
Well, it's right, okay. Yeah, yeah, no, that will be the problem.
No, injuries with a salad.
Lustration, he will also.
So forehead and face.
And that case was also succeeded by, but against the victim, my lord. The two contradicting versions are there, my lord, in this case, my lord. One is the accident and another one is by this.
Kindly tell us on which date the incident occurred of death.
Incident as per the FIR, my lord, is
35,
35,
2014.
Yes, 35
The
and they
incident
have
of
lost the
theft
FIR. No, no, continue.
Incident of theft occurred.
The theft
Right.
is, let's
Ah.
say,
Kindly tell us when the FIR was launched.
the FIR was believed because it is the authority has lost their charge sheet in my lord. I've got the.
Tell us when the FIR was lodged in that case.
The FIR seems to be 31.5 in incident is 35. Oh, serious. Oh.
As per FIR, it is mentioned in the charge sheet, my lord. But kindly go to page 8/8/2014.
When the incident occurred.
Delay is there, Mr. That is there. Delay part is there because it is lost by the authorities, my lord. This is after they have to make inquiry into the incident, my lord.
Incident occurred on 30th of
35
May,
May.
2014.
Even the president, informer, every party also lost their affair after 3-4 days, my lord. Not they instantly lost their affair, my lord. After coming to know about the occurrence, my lord. They also, there is delay on their part also there. But this delay is because of the inquiry has to be made, my lord, by the authorities, my lord. Regarding that, bridge was collapsed, my lord, and that the person involved also. There is
Itu FIR লিখিল লগোৱা নাই ন এটা?
It happened one another. In that case, we have to append with the record. Charge sheet will be available. Why is the case for the investigation once? One after another, my lord, final report was submitted. এই কেছটো ষ্টেটাছটো কি হ'ল গম পাব নেকি? এই যে এইটো কেছ আৰু এজন একো আছিল ন? এজনটো মৰি গ'ল ন? এইটো এইটো ষ্টেটাছটো ন? এইটো ষ্টেটাছটো আনিলে গম পোৱা যাব। Regarding the other FIR, into the National Highway Authority. So there were two issues, one died. That means they activated against it. The other one, that was reported to us. So in that resulted in some kind of conviction or like that, then this goes. That's really wicked. We hate to provide it possible. Either of the one left to both cannot go together.
এইটো চাব লাগিব এই
It to show the status to Sunny.
এইটো কেছ নম্বৰ কিবা আছে?
আছে আছে। এই annexed final show. Annexed final appeal check. The status of that present case is
Only
to make you fix as they explain. Nothing else.
video of department is an inpatient thing. That is good.
Left going to slide.
Because we have to go to the start record. Postmortem of the mind, blunt. Postmortem of the blunt. All of call them blunt. Start to go color.
লিচু ওপেন চাৰিটা এটাতো দোকান নহ'ব এটা ব্ৰিজত আৰু জংঘলত তিনিটা থাকে কোন স্যার এই 299 আৰু কাক চাৰ্জ কৰিছে injured he is on the accused felony আচ্ছা ইটো কত চাষে 299 Population case নাকি পাইছে দে আমার 98 মোট 98 Only 98 or was 299 কিন্তু দুটা চার্জ করে পেলাই হেৰি কৰিলে ন এটা করতে করতে একটু চলে আসে এটা 299 ঠিক হয়েছে হ্যাঁ 299
Conviction holds is on a killing. And if you compare to this, that.
এটা পেতে 2014 হলে ন তো কনভিক্ট হয়ে যাবেন কি সোসাইটি
এইটো রেকর্ড তো রাইট এইটো রেকর্ড কল করা হয়েছিল এই রেকর্ড কল করা হয়েছিল আগৰ পৰা নোটিছ দিয়ে আই ক্যান নট কল করা হয়েছিল রেকর্ডিং আছে
কিছু রেকর্ড আছে
Ms. Jahan,
Not. I'm told that the incident, that accident case is all, the record is here. So what had happened to that 299 case can be seen where the charge sheet is filed saying that it was an accident. And the victim and another person was arrayed as an accused.
on the record,
Not yet.
go to this. This is an independent witness who made a statement before police, before the magistrate.
Acha, acha. I've seen 164 statement also
Whom?
of naam to kya?
I would.
5 witnesses rather. There are
Who's,
164 of Akhtarun Nessa,
You have the 164 of Farooq Ahmed.
Yes.
Abdul Mannan,
Farooq Ahmed is there.
Go to the Farooq Ahmed.
Farooq Ahmed.
He has nothing to do with this.
Yes.
He's a purely independent.
Only anyone.
Farooq Ahmed, yes. He's 164.
If you can
Like-
read,
Incident is of last year on 35.
can you read the vernacular?
I can read, I think Jua বছর নাকি
গত বছর।
গত আচ্ছা, this is Bengali, not difficult.
Okay, read the contents, you'll know.
হ্যাঁ
Read the contents, you'll know.
he can read, because গত বছর
মেরি না। গত বছর 30/5/2014 ইংরেজি তারিখের ঘটনা। সেই দিন প্রায় 6:30 কোটিকার সময় আমি গোমড়া বাজার হইতে
থানা
থানা
থানা রোড হইয়া আমার ঘরে যাইতেছিলাম।
যাইতেছিলাম,
তখন আমার সঙ্গে খায়রুল তালুকদারের কাকাতো ভাই ফখরুল ইসলাম তালুকদার ছিল। সেই সময় খায়রুল ওনার বলেরো গাড়ির খুব স্পিডে আসিয়া আমাদের নিকটে থামায় আর ফখরুলকে বলে যে সবির আহমদ তালুকদারের অ্যাক্সিডেন্ট হইয়া গিয়াছে এবং ফখরুলকে গাড়িতেও উঠার জন্য বলে। খায়রুল, ফখরুল ইত্যাদি আমাকে চাচা চাচা বলিয়া ডাকে। সেই জন্য অ্যাক্সিডেন্টের কথা শুনিয়া আমিও ওনাদের সঙ্গে যাই। গাড়িটি মালিডরে খায়রুলের দোকানে যায়। সেখানে আমি সাবিরকে আমি মুখ বান্ধা রক্তাক্ত অবস্থায় পাই। সেইখানে আমি আব্দুর রুফের অ্যাম্বাসেডর ট্যাক্সি গাড়ি খালি অবস্থায় দেখিতে পাই। তখন আমি সাবিরকে আব্দুর রুফ কই আছে বলিয়া জিজ্ঞাসা করিলে সে আমাকে কিছু বলে নাই। আর তারপর তাহারা সাবিরকে সঙ্গে নিয়া কালাইন হাসপাতালে যায়। আমি আব্দুর রুফের সন্ধানে রইয়া যাই। তখন খায়রুলের দোকানে সাজুল, তাজুল, মঞ্জু আহমদ, আলাউদ্দিন আর আরো সাজুলে বাগিনা, কালা আর অন্যান্য ছিল। আমি তাদেরকে আব্দুর রুফের খবর জিজ্ঞাসা করিলে তাহারা আমাকে কিছু না বলিয়া আমাকে চুপ তাকিতে বলে আর কয় যে সেখানে সিআইডি আছে। তখন আমার সন্দেহ হয় আর আমি আব্দুর রুফের মোবাইলে ফোন করিলে ফোনটা খায়রুলের দোকানের ভিতরে বাজে। তখন সাজুল দোকান হইতে আব্দুর রুফের মোবাইল আর একটি টর্চ আমাকে দেয় আর বলে যে সে আব্দুর রুফকে দেখছে না। তখন আমি আব্দুর রুফের ভাই আব্দুল মন্নানকে ফোন করিয়া খবর দিলে তাহারা আর লগে আব্দুল হান্নান আর কয়েকজন মালিডরে খায়রুলের দোকানের নিকট আসে এবং খোঁজ খবর করার পরে কিনারে একটি জঙ্গলে আব্দুর রুফের রক্তাক্ত শরীর খুঁজিয়া পাওয়া যায়। সেই সময় আব্দুর রুফের শরীরে জান আসিল আর ওনার মাথায় জখম ছিল। তখন আব্দুর রুফের ভাইয়েরা ওনাকে কালাইন হাসপাতালে নিয়ে যায় আর আমি আব্দুর রফের অ্যাম্বাসেডর গাড়ি নিয়ে ঘরে চলিয়া যাই। আমার বিশ্বাস যে খায়রুল আর তাহার সহকারীরা আব্দুর রফের হত্যা করিয়াছে।
That is his, but whatever the finding is most important is that he is an independent person. This Khairul came according to this man. We are not in investigation stage. That he came in his bolero in an accident. Parked the vehicle behind his brother, inform him that this man has, yeah, rather the other person sustained injuries in an accident. So they got up in the vehicle. This man also entered in that vehicle. Went there, found that person with heavy injuries. His face was tied up, and then they took him to the hospital.
Oh.
Allied Hospital.
Yes.
Now at that stage, the telephone of
It was
Mrs.
inside the
rang
shop.
inside the shop. So it was given by one employee of that particular shop. And they asked for him, where is that man? They could not find. So from that mobile, he has informed the family members of the deceased. They came there. After making search, they could not find them. Thereafter, in a jungle nearby their shop, the deceased
Near
was
the
found,
shop, yes.
right?
Yes,
So
was found.
somewhere, and one interesting part, that affair, the second affair against in which the deceased was the accused. There you will see it was lost after 2-3 months later.
Fourth.
And then what the affair, 2 persons have committed. Where from there was no eyewitness. Where from they could come to know that the 2 persons have done it.
Persons had committed. One of them being the accused, I
And the
think.
other, because according to them, the other person fell down.
Yes.
Other person fell down, very specifically, where from they came. There was no eyewitness to the incident, how they come to know only the 2 persons.
Only
have
2
committed.
persons. So something needs to be.
Definitely, that itself indicates where from they will come to know. The informant was a nobody because he was not in the scene, he did not see the incident. Where from he will know that the 2 persons committed the crime. They fell down, and because of he fell down from the top down below in a rock, so he died in the spot itself, and then the other person sustaining
Injuries.
right. There was only the IO have said that some plates were found near the ambassador car of the deceased. No one else has said that.
But there is something more is there.
So, and above that, we are not here to do any inquiry. Yes, Mr. Ali.
Well, at this stage, well, I will. Because there cannot be 2 versions in this case, my lord. Either one has to be true, my lord. Either this
That
case
the
or.
trial will see.
My lord,
Why this-
no, but what happened to the other case, my lord? Because that case was succeeded, my lord, because that theft case, where the victim is involved along with another person.
Can you tell us, Mr. Ali, where from they got the information at midnight or whatever time? Only 2 persons have committed that crime?
No, that maybe the inquiry was made by them, man, because immediately the authorities cannot have received any information, my lord. Because the remote area, my lord, this Brace was not indicated that it can visible in a remote area, my
So
lord.
basically, one more important factor is there. One of the witness in 164 made it very clear that in the shop of the Khairul, there are blood stains.
They were cleaning.
They were
Yes.
cleaning.
They were cleaning.
But
That I got it.
that the police did not investigate that aspect of
But twice there was investigation was done. One
Investigation,
directed,
as
my
you
lord, reinvest, further investigation was done.
that part is very clear in that 164 statement. And the
Time
IO
declaration is also.
in
there.
the
No diagrams in this.
final report, there is no mention that they have come to the, they said place of occurrence. The place of occurrence where is the car was parked. It is not that the inside the Khairul shop.
Yes.
They did not say anything in.
Car belonged to the victim, my lord, not this Khairul, or this petitioners, my lord. The victim's own car was parked. He was driving there, my lord, with the purpose of committing the theft. It is not a case that this
Will pass order.
Lot.
let the matter be, my
You know
lord.
very well, Mr. Hazarika, where to use 482, right? There cannot be any such ground at this stage to
My lord,
interfere in the order of the London
Let the
magistrate.
matter be part for hearing, well, because my lord, at this.
Tell us if there is any material, tell us. If you are relying
What
any.
kind of final
tell us.
procedure on the, because twice the matter was investigated.
That is why.
Final report was submitted by him.
Maybe that cannot be a
Right.
ground. The magistrate is satisfied on the basis of the statement and the inquiry on the section 200 and
And
200.
then he has not applied by mind,
Tell us.
because
The other case is also there, my lord. That ought to have been considered, my lord, regarding the theft case, my lord.
Mr.
Without
Africa,
considering
with your
anything, nothing was
experience-
reflected, my
With
lord.
your experience, will you able to tell us?
My lord.
Will you able to tell us how come only 2% were there in the next FIR? It may be 4, 6, 8, maybe 1.
Lord, they might have made an inquiry, my lord, to the
Can you
police
tell
or
us?
my lord, something. Otherwise, my lord,
Now it is
there
on
cannot
the
be two
basis of
versions,
the-
my lord, in this case, my lord.
Kindly tell us why the order of the magistrate is bad.
Because it did not apply his mind, because
Why-
with regard to the other
So
case,
was-
my lord.
so was the
There is
order.
nothing is reflected, my lord, with regard to the
was the
other case,
order.
my lord.
So was the order.
And the order is at page 44, my lord.
And read it and tell us where is the illegality.
And only mechanically he have proceeded, my lord.
Kindly
But
read.
that is complainant is present along with one
Kindly read.
witness under section, and same version of what was there in the earlier, my lord, 164, and that same
Mr.
version, my lord,
Hazarika,
in 202, my lord.
Please read that
Now,
order.
now the court has to go at the present, my lord, materials.
We are asking you to read that order.
Is that at page 44, my lord?
Yes.
Complainant is present along with one witness who is examined under section 2027. His statement is recorded under section 2027 in a separate sheet of paper and is tagged with the case record. The complainant has stated that he has no more witness to produce. I have perused the complaint petition, entire case record, statement of the complainant under section 200 CRPC and statement of the complainant's witness under section 202 CRPC. On going through the statements of the complainant and his witnesses, it is found that there are prima facie materials to proceed against the accused person, namely so and so, for offenses punishable under section 302/34 of the IPC. Accordingly, cognizance of offense punishable under section 302/34 IPC taken against the above name accused persons. So that is my lord. I mean, so my
So
lord,
what else the
what was
magistrate is
the
required to do?
version of the earlier version, same version, they have lordship will kindly go to the statements, my lord, which under now lordship will they have to consider only the statements, my lord, under 200 and 202, my lord. Other will not be taken into consideration, my lord.
Because the
Lordship will-
informant
Yes, my lord.
filed an objection petition, Naradidama, right?
Right.
So that was considered,
That was
considered, that was been converted to an complaint.
Yes, sir.
So,
The second time, my lord. First time it was.
right.
There was
So first time it
petition,
was
re-
directed for
direction for
reinvestigation, right?
further investigation, my lord.
Further investigation order was
No,
passed.
lordship, that 164 statement earlier will go now. That has no relevance now, my lord. Now
Now-
this court has to
That is why the 11th
proceed only on the
magistrate-
statements under section 200 and 202. The other part statements will not be considered, my lord, my lord. Because it's now has become a complaint case, my lord, now, my lord.
That is why
What earlier verses will not be taken into
other
consideration.
statements have been recorded.
So let us examine, my lord, what under section 200, that page 45, my lord. Kindly remember this statement of the complainant, my lord. That's page 45. I am from married, madam. Only because he was found injured nearby the shop of the petitioner, my lord. That is the number one, my lord. That is the only suspicion, my lord.
Anything else, Mr. Hazarika?
And then the other statement of the witnesses, my lord, that is page 46, my lord.
Anything else?
So these statements, my lord, does not justify that the court should, my lord, take cognizance, my lord, because against the petitioners, my lord. These materials, my lord. And in view of the other case or the accident case, nothing is reflected in the order sheet, my lord. That ought to be considered, my lord. Nothing is there, my lord. In the order dated, impugn order dated 29, my lord. The court has totally kept silent on this aspect, my lord.
In fact,
So
these
both
two
the things
cases
should be taken together, my lord.
should be taken one after the other.
Together, it should have been
Not
taken together.
together, one after the other, 210.
No, that is 210, yes, sir. That is complaint.
Both the cases,
Of
FIR.
both the
and-
cases, yeah. They
So
should be
that
taken-
two contradictory orders are not
Actually,
passed.
both that cases should have been taken together, my lord. Otherwise, that it will be, there will be contradictory orders, my lord. If that case at the ends in conviction of the accused, my lord, other accused who was alive, then it will be contradictory to the allegations, my lord. This
Yes.
doesn't get, my lord.
Okay, Mr. Hazarika, we have
You
noted
can-
down
The
that.
matter be admitted, my
Yes.
lord. and
I am for
not
the
hearing, my lord.
respondent, but I have submitted objection, Lordship.
Hmm.
And I have annexed the witnesses under statements of witnesses under section 164, Lordship. Five witnesses are there, Lordship. And Lordship also find it in the Lordship record also, Lordship. All the five witnesses categorically stated, Lordship implicated all these things, and Lordship, the informant, Lordship, who was after phone call, Lordship, went there, Lordship, Abdul Hannan, page 62 of my Lordship. Objection, Lordship, Mary, Lordship.
We have seen that.
Yes, Lordship. And there, Lordship, what happened in this case, Lordship, there is a brutally murder was happened, Lordship, and thereafter it was tried to make it as an accident case. Lordship, and I have two judgments, Lordship. My Lordship, one is that, Lordship, Sona Gupta, Lordship, but Lordship, here, Lordship, the Honorable Apex Court, Lordship.
Kindly give me this.
Yes, Lordship. So please, dear Lord. Case Lordship, Sona Gupta, Lordship, paragraph 8, kindly read. For a moment, paragraph 8, Lordship. May I read, Lordship? Having
Mr.
con-
Mozumdar, right?
Yes,
Which paragraphs?
paragraph 8, Lordship,
8
Lordship,
and
8 and 9, Lordship. Paragraph 8, having considered the details of allegations made in the complaint between the statement of the complainant and Shaman, a solemn affirmation as well as materials on which the applicant placed reliance, which were called for by the learned magistrate. The magistrate, in our considered opinion, committed no error in summoning the accused person. At the stage of cognizance and summoning the the magistrate is required to apply his judicial mind only with a view to take cognizance of the offence, or in other words, to find out whether prima facie case has been made out for summoning the accused person. At this stage, the learned magistrate is not required to consider the defense version or materials or arguments, nor is he required to evaluate the merits of the materials or evidence of the complainant because the magistrate must not undertake the exercise to find out at this stage whether the materials will lead to conviction or not. It is well settled that cognizance is taken of the cognizance is taken of the offense and not of the offender. Hence, at the stage of framing of charge, an individual cause may seek discharge if he or she can show that the materials are absolutely insufficient for framing of the charge against that particular person accused. But such exercise is required only at a later stage, as indicated above, and not at the stage of taking cognizance and summoning the accused on the basis of prima facie case. Even at the stage of framing of charge, the sufficiency of the materials for the purpose of conviction is not the requirement, and a prayer for discharge can be allowed only if the court finds that the materials are wholly insufficient for the purpose of trial. It is also a settled proposition of law that even when there are materials arising strong suspicion against an accused, the court may be justified in rejecting a prayer for discharge and in granting an opportunity to the prosecution to bring on record the entire evidence in accordance with law, so that the case of both the sides may be considered properly. So, my lord, at the stage of cognizance, lordship, magistrate has rightly, lordship, considered the case, lordship. And in another case, lordship, perhaps this Umar Shankar Singh, lordship. Here, the present case is perhaps similar, lordship.
Paragraph 19, Lord. The law is well settled that even if the investigating authority is of the view that no case has been made out against an accused, the magistrate can apply his mind independently to the materials contained in the police report and take cognizance thereupon in exercise of his powers under section 195. This is precisely what happened in the present case. 20. In the instant case, the investigation had been handed over to the CID, and both CID and the local police had submitted the reports in final form, exonerating the petitioner of the allegations made against him in the FIR. However, the Chief Judicial Magistrate one took cognizance of the offence under section 302, 379, and section 27 of the Arms Act against the petitioner. This is not a case where the magistrate took recourse to any further inquiry, but take cognizance from the police report itself, which he was entitled to do. So you can do lordship. And at the stage of cognizance, lordship, they may appear and lordship.
Okay, we'll consider. Yes, Mr. Hazarika, would you like to place anything? Heard Mr. Hazarika and counsel appearing for the petitioners.
Well, one judgment only on my, I am submitting my lord, regarding the same one point, my lord, that magistrate has to supply his mind independently, the 2019 8 SCC, page 27, my lord.
2019,
8 SCC, page 27. my lord.
8 SCC, page 27.
Correct.
11 paragraph.
A relevant paragraph, my lord, is, parent and para 9. man. The magistrate to apply his mind independently. That is the only thing. The materials earlier on the here case that has to be ignored, my lord. Now only the court has to proceed on the basis of the materials under which when the materials available on the basis of the complaint, my lord. Only that is a statement under section 200 and 202, and then appears that it only mere suspicion, my lord. Only to shield the guilt of the this victim, my lord, who was involved in that case, or they have lost this case after 3-4 days. That too, they have also not lost this case instantly, my lord. On that part also, there is a delay, my lord. If they have suspected that there is a murder case, immediately they should have, my lord, lost the case, my lord. They are also delayed, my lord. They are also delayed, my lord. That is not explained, my lord. The delay, my lord. And para 27 also same thing is stated. What is relying on is the earliest 164 statement of man. That's Will be found in the protein that is final to the input presentable data on listing by the
Miss Jahan. So it has become two versions. By this judgment which Mr. Hazarika has placed before the court,
Hmm.
that he expressed complaint petition, because what happened? The case starts is that the one lady
One lady.
expired.
Hmm.
Her father lodged an FIR
Hmm.
saying that prior to date, his daughter, she informed him that father-in-law, mother-in-law, sister-in-law, and her husband was demanding dowry, car, and everything. And as it could not be given to her, they were physically torturing her, physically, mentally, all cruelty. So after the death of his daughter, he lodged his affair against father-in-law, mother-in-law, sister-in-law, her husband. Son-in-law. So printer proceeded, filed the final report.
Hmm.
The investigation, no such materials to prosecute those persons could be found under 498 and others. So filed a protest petition. The magistrate rejected that protest petition and accepted the final. Then
Second
the
come,
father of the deceased filed a revision petition,
revision petition.
which was also dismissed. Then the father approached the High Court, filing 226 to 27 application. Therein, the High Court directed the magistrate to accept that protest petition as a complaint petition and to proceed with the matter. Against that order of the High Court, the son-in-law preferred an SLP before the High Honorable Apex Court. In that circumstances, the entire matter was discussed.
Where is it?
Here,
Hmm.
everything was discussed. Ultimately, the Honorable Apex Court has said that separate petition, a criminal petition is required to be filed. All these times, it was is that if, see, the judgments are very clear. It will not be on the basis of the earlier application filed by the complainant.
Hmm.
It can be considered as a protest petition.
Hmm.
It's to be always a fresh petition.
Hmm.
It cannot be the previous petition.
Hmm.
That's the law.
Hmm.
It's a very old judgment.
Hmm.
Apex Court.
Yes.
So each time anything final report is submitted, there is a requirement of filing of fresh protest petition. Not on the basis of the earlier application.
Hmm.
File
Not
or
on the
complaint.
basis of the FIR, that earlier application.
Any such
Anything.
protection,
Hmm.
if you're on the basis of a complaint, if some police case is registered, that previous complaint cannot be considered as a protest petition.
No. Hmm.
Or also
File.
there is also a judgment of the Apex Court, you will see that the complainant, the informant or the complainant cannot say that I have already filed a complaint petition on the basis
That
of
he
it.
cannot. He has to file
That
afresh.
cannot. He has to file afresh, objecting the reasons
Acceptance.
about the final report
Hmm.
and why it should not be objected
Hmm.
and why it should not be considered, it should be rejected. So a fresh application or fresh complaint is required to be filed by the informant.
Hmm.
And then the Honorable Apex Court, they ultimately set aside the order of the High Court, saying that the complainant is required to file a fresh petition.
Hmm.
But I have not gone through all the paragraphs, only have the few first paragraphs on the basis of which the facts of the case.
Hmm.
And then in the later stage, we have seen that particular direction. And then, of course, it was found that already the informant had lodged a complaint,
Hmm.
which the magistrate can prosecute.
Hmm.
That was the direction.
Hmm.
We'll consider and pass an order here.
But in that case, magistrate did not accept the Naraji petition and he quashed it and he.
Yes, here in this.
Here,
case,
in
Mr.
that
Hazarika,
case.
which clears it.
Huh.
But later part of the judgment, after discussing all these judgments, the Because this is a case where the matter arose from a protest petition and in fact, the father of the deceased lost filed a protest petition on the basis of that.
Complaint. Oh.
Do you have the copy of the judgment, Mr.
Yes,
Hazarika?
Lordship.
Okay, give it to her.
There is another one, my lord, Adalat Prasad case also is there on this point, my lord. But they're very
We'll
relevant
get
case,
back
my
to-
lord.
we'll
We
get
have
back to
it relied on many cases now. On this. Not that one, but-
Come to para 50 straight away.
50.
Yes.
The High Court, in fact, in paragraph 11 of the impugn order, which we have extracted, contemplated consideration of the protest petition so that cognizance may be taken under 191B of the code. This premise being without any basis, even for the other accused, who are the relatives of the appellant, we would think that the impugn order must be set aside. Having regard to the nature of allegations and in exercise of our powers under 142, we must set aside. Yes, this is what this order of the High Court is wrong.
The last part.
We would think that in the facts of this case, the High Court erred in intervening and that there was no justification in the facts for the High Court to set aside the order. Because magistrate had dealt with the protest petition and he did not accept. After that, High Court again saying you consider that is palpably wrong.
That's right. That's how the facts are different. That's what I said. The last direction.
Resultantly, the appeal will stand allowed. The impugn order of the High Court will stand set aside. We, however, make it clear that this would be without prejudice to the right of the second respondent to file a complaint as already noticed in the order of the additional session judge. Of course, he can file always a second complaint.
Always.
But in the facts of our
Here,
case,
that
they
is,
have
that is the difference in this
Ah.
case. Because in that particular case, the magistrate accepted the final.
final report.
Here is not the case.
Here's not the case. Initially, they have given it for further and thereafter they took cognizance. And after recording, after having recorded statements under 202. 202 speaks of some dying declarations
But
also.
that direction regarding that is not there in the FIR, my lord, earlier. That should have been there in the first instance, my lord. Subsequently, they improved their version, my lord. That cannot be there. In the FIR, it is not there, my lord.
We are not here at the merits of the case at this stage, Mr. Hazarika.
Complaint
No, no, but
That will be only the.
that is the, I am just
because-
bringing it notice the lawsuit, my lord.
Anyway,
That-
which
they
is the
are-
other
now they have
judgment?
come with this version, new version, my lord.
Which is
It
the
should have been
other,
at the first instance, my lord.
which is the other judgment you are relying on?
Aroda judgment was not.
But why Adalat Prasad, if you want to put it.
Adalat Prasad, though, we have read.
Regarding that, taking cognizance, by.
But it's not a case where there are no materials. There are.
No, they
And
are
the,
only on
cited
suspicion, my
as-
lord, only because, and complaint, my lord.
Adalat Prasad Lordship knows that Matthew case and all were referred and then Section 200 contemplates a magistrate taking cognizance of an offence on complaint to examine the complaint and examine upon oath the complainant and the witnesses present, if any. If on such examination,
They are stating 15.
more 12 portion.
Oh, okay.
If on such, what, there it was, if on such examination of the complainant and the witness, if any, the magistrate, if he does not want to postpone the issue of the process, has to dismiss the complaint under section 203. If he comes to the conclusion that the
That's
complaint,
that to the complaint petition.
no complaint
The
petition,
magistrate's power and how to
Ah.
exercise.
postponement of process and
How
all.
it's related to this matter.
14, he
How-
is saying, but after taking
That's 14.
cognizance, paragraph 14.
14. 15 is one.
It is true that if a magistrate takes cognizance of an offence, issues process without there being any allegation
Allegation.
against the accused or any material implicating the accused or in contravention of the provision of 200 and 202, the order of the magistrate may be vitiated, but then the relief an aggrieved accused can obtain at that stage is not by invoking 203 of the code because of CRPC does not contemplate a review of the order. Hence, in the absence of any review power, inherent power, the remedy lies in invoking 482. But this is a case where it is said no materials, but here we see some materials.
Kindly give us the citation, Ms.
This is 2004-7338.
Relevant judgment in regard to this point, my lord. That's my case is there, but what will happen, will happen to that other case, my lord? That accident
Double
case is already
three.
there, my
They
lord, that's
can-
just seated, my lord.
Both the cases to be taken together.
2004 7 is
Both are
double
contradictory.
three eight.
No, no.
338.
Hmm? No, get to put it for. It was said,
Let him get the information what happened to
Oh,
him.
but we have to take instruction that there are other case, my lord, because if that case in the meantime has proceeded some stage, my lord, then, and which is contradictory to the
Next on
present
19.
case, my lord. Then it will have a relevance.
We are
to-
fixing it on 19th
Lordship.
for necessary order.
This other case is completely different, my lord.
Let him get the
Opposite to the
instructions.
version of this case, my lord.
But
It
the
is an accident
magistrate, it
case,
is the
and that is
duty
lost
of,
by an authority of government of India, my lord, not by a private person, my lord.
and it
That
is
will
the
be a
duty
different
of the
case.
magistrate to hear it together one after the other.
Much obliged.
Maybe, Lordship, after sometimes, Lordship, senior is another.
Mention question. We should resource, like. Document input. Signing.
Or after some time.
After some.
Miss Jahan,
Lordship.
by the last order,
Hmm.
the court wanted to know from the state
Hmm.
whether any confiscation proceeding has been initiated against the seized vehicle
Oh, acha,
and
that,
also call for the case diary.
that we don't
Do you
have
have
it
a copy
today.
of this order?
No, Lordship, I
Okay,
don't have.
okay.
But then, someone has written on the last occasion, call for a report along with the CD. That is not there. Lordship will take it up on Monday or Tuesday. I'll get the report.
This is from Kamrup only.
I'll get the report
And this
on
is,
confiscation and the CD as well. It's a commercial quantity. I'll get the report.
enabling MS as Jahan, Additional Public Prosecutor. Has been directed by this court earlier on 23/07/2024. List this matter again on
5th August.
14th August.
Lordship.
Lordship. Short date, maybe. Short date.
Ms. Jahan, today is second.
3 second.
When
Any
you able
date,
to-
Lordship? I'll have a telephonic conversation. I'll bring it. Any date.
5 August, Lordship.
9th.
9th, Lordship.
Obliged. Lordship, I am appearing on behalf of Mr. Amit Goel, and Lordship, the petitioner's counsel is out of station.
Here also LCR and CD was called. Perhaps it's here. It's here. Opposite.
Respondent.
The Honorable High Court in its bail order has said that no misappropriation had taken place. That Lordship can see at page 28.
But thing is this, there is a judgment. This has happened in earlier one matter, we know. Somehow these kind of order where there is in the bail petition some directions or something that cannot be issued, and that is in the apex could have made it clear.
That cannot have any
Has
effect.
not to be exceeded in certain petitions.
That's
Only for
right.
the purpose of bail that may, but has no impact on the other case.
Impact on, yes, yes, that is ruled.
Lordship, I
It
beg to-
happens, it says sometimes the honorable judges may do that, but has no such things in it.
On the main case, that will
In
happen.
fact, it happened earlier in from our high court, matter went to the apex court. While granting bail in a land grabbing matter, the court person or it's a bail matter about the rights of the person. Then it is almost, it's not a civil case to decide.
Yes, of course.
So the aggrieved party went to the apex court. Initially, a petition was filed, it was not interfered, so went there. And there also, it was said that that should not be considered. in the
That should
other.
not be.
He was giving in the decision of the other. court.
Lordship, I beg to seek adjournment in the matter. Lordship, the petitioner counsel is out of station.
That's true. Yes, because of some other reason, we have been looking into the records. There is a reason behind that. Please hold on. What's your good name?
Divyansh Rathi.
Counsel for the Amtuli. Appearing on behalf of Mr. Ray Goel, counsel for the petitioner. and prayed for adjournment of the matter as the leading counsel, Mr. A. Goel, is out of station. Heard MS as Jawaharlal Regional Public Prosecutor ready for the state testimony. It is seen
She is
that-
appearing for the informant.
Lordship, I'm appearing for respondent number 3. Union Bank.
notice on the respondent number 3. Union Bank of India. Manager, Union Bank of India, Dhubri Bunch, has been duly served. What's your good name?
S. Yasmin.
Miss S. Yashmin, learned counsel, has entered appearance on behalf of the respondent. Office note dated 20-07-204 reflects that notice on the respondent number 2 could not be served as no such person was found in the address given. Considering the above, the petitioner is directed to take fresh steps on the respondent number 2 on or before 12th of August, providing her correct and proper address with requisite postal stamp. List on.
Lordship, may please to provide a short date.
How can it be? That is the reason we have been looking into the records to find out the address of the respondent number 2. Anyway, it is now your duty. After registered post, you have to give 30 days. Thirteenth of September.
Much obliged, Lordship.
Lordship, we have taken steps.
Yes, you have taken steps on the respondent number 2 and
Lordship, on 3/11/2022.
huh?
3/11/22. Nine.
Which date? 3/11.
3/11, Lordship.
Not the box on it.
376. And Nalaga, I think.
376 AB.
Ito Nalaga.
Office note says like this. Notice was issued before 1 year, 8 months on 18/11/2022.
Lordship.
Yet no service report has been found.
Lordship.
While checking receiving file database.
Lordship.
Okay.
376 is otherwise not mandatory for,
As per
I
notification.
think A, B, few of 376 sub clauses, it's mandatory.
Matter relates to service of notice on the respondent number 2, victim/informant. Where is the office note? Verma. এটা কি বলি পড়ি? Please can't match. User by two points. 31/07/2022. Matter be placed before the Lozima court for its necessary finding and a report. List on 21st of August. Yes, Mr. Doctor, you are appearing for the respondent,
Respondent, Lordship.
none for the petitioner.
No, Lordship. Appeal against Secretary, Lordship. I am the accused person. I have been acquitted. LCR, I think received lordship.
None appeared for the appellant. Appellant, single appellant, I believe. On call, the name of two councils have been reflected into court. So letter of absence আছে নাকি? Sharma? Rona, Rona. Third, MS Andas, third, Mr. P.P. Dutta, Planet Council for the sole respondent. Matter relates to appeal against acquitting the respondent number 2. Accused in NI case number 18 of 2015 by the United States Judicial Magistrate Golaghat. By which order? By order dated 30/11/2019. List after 2 weeks on a date to be fixed by the registry.
May I please? Lord,
You are appearing in this matter, item number 8.
yes. Lord, this is an appeal against the conviction under the POCSO under section 4. And the total imprisonment was, my lord, 8 years. And along with the main appeal, my lord, one IA petition has also been filed to prefer the interim suspension of the sentence and to allow the accused convict to go on bail with any condition, my lord. Because he has already suffered more than 15% of the imprisonment. Out of total 8 years, 5 years already completed. Only just 3 days, 4 days short, my lord.
The office note clearly reflects that steps on the informant respondent number 2 have not yet been taken.
My lord, the steps were taken lately. Yesterday, we have taken steps when we have found that the earlier engaged counsel has
Just
not
give us
taken
his
any
receipt.
steps. My lord, this is, yeah.
As you know, here is being a POCSO matter,
Service report is
has to be there.
at lodge.
You have taken by registered post.
Registered post, my lord.
Okay. Let. Where is the office note dated 24/7/2024 and 30/07/2024? The appellant has taken steps on the respondent number 2 by registered post authority. Yesterday only, by on 01/08/2024. The appellant is also allowed to take steps on the respondent number 2 to the officer in charge of such and such query. Say there is a notification from the High Court that steps to be taken if in the POCSO matters to the Office of the Public Prosecutor of this High Court, and then the concerned public prosecutor shall send it to the, not the public prosecutor, Office of the Public will send it to the concerned police station of the informant and will obtain a report regarding service. So we are directing you to take steps in with the Office of the Public Prosecutor of this High Court. You shall take
Your respondent is the state of Assam represented by PP.
the victim informant. You have not made the informant, that is respondent number 2. Take fresh steps on the respondent number 2 to the Office of the Public Prosecutor, Guwahati High Court, on or before 7th. ठीक है? After the order to office. List on 6th of September. We'll pass the order in that case. Terracotta Khalil Likhas. Registry has already received the 11 records from the court of learned special judge Pokso Hemaji. Karbi Angon. Karbi Angon.
Take steps. My lord.
Item number 9.
May I please one question? In this case, as for honorable court's directional,
I will appoint as an amicus for the respondent number 2.
we have filed our objection also.
Pursuant to the order the 2106-2024, Mr. Sarfaraz Nawaz, learned counsel, has been appointed as the amicus curiae to represent the respondent number 2 in formation of the case. Heard M.S.R. Begum, learned counsel appearing for the petitioner, and M.S. and thus learned additional public prosecutor appearing for the state respondent number 1. Also heard Mr. S. Nawaz, learned amicus curiae for the respondent number 2. The state has already filed its objection in the matter in granting bail to the appellant. Registry shall reflect the name of Mr. S. Nawaz.
It's already been reflected.
It's
It's already been reflected, my lord.
9. Oh,
In that.
9 down, okay. Really good. List on. Sixth, we'll consider on 6th. You make a mention in the morning.
Indeed, you agree.
Lordship, service report not received, Lordship, and item number 10.
Already taken steps for the
1 week, Lordship. Time may be given, Lordship, for inspection.
Okay. Heard Mr. A. Mohammed, counsel appearing for the appellant. Here is the office note dated 26/4/2024. Appellant is allowed to take steps on the respondent number 2. To the office of the public prosecutor such and such for a order to sell about Mr. Ahmed to take steps on the office of the public prosecutor on 7th, or not before 6th. It has to be
my lord, already take steps, my lord.
on whom, through what,
To public prosecutor, my lord.
when?
On this case, my lord. As per office note, my lord.
Office note did not reflect anything.
Reflected, my lord. As per office note, reflected, my lord.
Not reflected.
Which will not-
Notice has been issued on 26/4/2024.
Date matter.
Returning into the appellant, counsel for the appellant for serving the same on the officer in charge of the concerned police station. What is this, Ms. Das?
Lordship,
The appellant should go to the concerned police station.
no lordship.
Read this report. I don't know. This is from your office. Mr. Sharma, you can also help. That is not the procedure.
Yes, lordship.
Okay. Follow the next item.
Okay.
Okay, I'm seeking adjournment in this matter because senior NB Chaudhary is out of station. And the last note, office note, the amicus curiae has been appointed and I have furnished a copy.
I've been appointed as a amicus.
Have you received a copy?
They have given.
You are Mr.
A Banerjee.
Counsel for the appellant. MS send us. Learned. Additional public question Assam for test number 1. Opposite party number 1. And Mr. D.K. Bhattacharjee landed amicus curiae for the opposite party number 2. I has not yet been considered.
Not yet concerned.
Have you filed any objection, Ms. Das?
State has filed.
State has filed.
State has filed.
Yes.
State has filed.
I file an objection.
Registry has also received the relevant reports from the court of Learned Special Judge Bongaigaon. Also to the special judge. Also Bongaigaon.
Also, kindly the date may be fixed on 12th of August.
6 or 12, you want on 12?
12th of August.
6th step, I have some problem.
Okay, on 12. Let be considered.
Obliged. Deeply obliged.
You make it on 13th.
Obliged.
You make a mention on 13th.
Obliged. Back to you, Lordship.
Yes, any such objection filed?
Item
Item number 12. We'll come back to you, Mr. Mutton. Just a minute.
This one, item number? 41. 12.
12.
Objection filed.
No report to.
My lord, objection, my lord, not filed. I have gone through my lord. This one, it is also there. Lordship, question is that, Lordship, the erroneous judgment, Lordship. Page 41, kindly, Lordship. Kindly 41, Lordship. Lordship. That means 302, 10 years punishment is given, Lordship. It is wrong, Lordship. So if matter may be.
Yes, Mr. Sharma.
My lord, I have gone through the, my lord, evidence of the, my lord, PWC's, my lord.
10 years for 302.
Yes, my lord.
Possible?
That is, my lord, that is. Its murder shall be punished with death or imprisonment for life.
Life imprisonment.
Yes.
Death only.
Yes, my lord. That is, that, my lord. Law is clear, my lord, yeah.
Clear lordship, only two punishment. One is life imprisonment, another is death lordship. So this may be 304 lordship part 2. So I think lordship matter may be remand back to rectify it.
Okay, we'll have it on Wednesday,
My lord.
but not on Wednesday. It will be better to have it on Thursday. 8.
Yes, sir.
On 8.
Yes.
You make a mention in the morning. Because sometimes the list is long and the order matter doesn't come. So we'll pass the order.
Hi, Lord.
My lord, I cannot, then, my lord, I'll inquire in office, my lord, and inform shortly, my lord. Regarding that, my lord, issue of notice, my lord.
Notice was served on you,
Yes, my lord.
but how come that office note clears that it has been given back to the, again, the appellant?
Yes, my lord. That report, my lord, but on office, my lord, that may not receive, my lord, and
Service report.
yes, service report, we have not received, my lord.
List on 9th,
My lord.
enabling Mr. B. Sharma, additional public prosecutor of the state,
No, service
to apprise the court as to whether notice has been served. The restaurant number 2 in this matter or not.
Service of notice and report. Report bill.
সেইবিলাক সব কাটি দিব আৰু AM Ahmed, B. Sharma.
Lordship, in this matter, PP have to file their objection, Lordship, as per order dated 26/6/24. The Honorable Court directed to file objection, Lordship.
NDPS matter, Mr. Sharma.
My lord, maybe it was filed on, my lord, yesterday. My lord,
No report.
yes, my lord. Kindly fix on, my lord, next week, my lord.
How could they file it yesterday without serving a copy?
No.
No.
Copies of problem.
My lord, it is actually, my lord, our office staff, my lord, serve copy, my
At least
lord.
on the
My lord,
appellant,
my lord, my lord.
without serving a copy on the appellant, how could you have filed it?
My lord.
RMSD Borgohai, counsel appearing for the appellant.
M. Sharma. M. Sharma.
Sorry, ma'am, sorry. I'm Sharma, appellant counsel for the petitioner. Sorry, appellant. / applicant. And Mr. B. Sharma, additional public prosecutor, Assam for the state. List on 13th. In the meanwhile, the state respondent shall file its objection on or before 8 without fail.
Highly obliged.
Please, the Lordship. Lordship, delay application. Lordship, on the previous day, there was some error manifest for calculating the delay. Lordship, by office note dated 31/7, the error has been notified. So Lordship, notice may go at this stage.
What's your good name?
Yes, Mr. Lordship.
For the applicant. And Mr. K. Boisho, learned additional public prosecutor, appearing for the opposite party slash respondent number 2. Matter relates to condoning the delay of 43 days in preferring criminal revision petition to connected criminal petition against the order judgment order dated 13/02/2024 passed by landed judicial magistrate first class Lakhimpur, North Lakhimpur, in this case number 89/2022 under section 125 CRPC, granting rupees 8,000 as monthly maintenance to the respondent number 1. Opposite party was known, wife of the applicant petition. Issue notice returnable by 4 weeks. As Mr. Abel said, could not formulate petition itself repeated. Applicant shall take steps for service of notice on the respondent opposite party number 1 by registered post with AD, providing her correct and proper address with registered present postal stamps on or before 0608. Notice returnable 4 weeks, is under 6 weeks. List accordingly.
Obliged, Lordship.
Please, your lordship. Matter may be adjourned for the day as learned counsel Mr. M. Smith has some personal difficulty, your lordship. Therefore, the appellant, lordship.
You are appearing for whom?
I'm appearing for respondent numbers 1 and 2, your lordship. On behalf of Mr. KP Pathak.
What's your good name?
Pardon, your lordship.
Your good name?
M. Kalita, your lordship.
Your good name?
K. Kolita. On behalf of M. Smith.
Mr. K. Kolita on behalf of Mr. M. Smith. And MS M. Kolita, learned counsel on behalf of the learned amicus curiae KP Pathak for the respondent numbers 1 and 2. Also heard Mr. K. Boisho, learned additional public prosecutor. Appearing for the state respondent number 3. List on 6th for hearing.
All right.
This Tuesday, matter is of 2010.
Lordship.
Obliged, your lordship.
Review petition dismissed. I being in fact was dismissed.
Deeply obliged, lordships.